Under what circumstances can a party add a claim for reformation during the trial? To find out, you have to read 3406 versus Seneca. It's only 13 pages. Don't have time for that? I got you covered. This is TLDR, Too Long Didn't Read, Court of Appeals cases in 5 minutes or less. This is the episode on the case of 34-0673 LLC, which is an address versus Seneca Insurance Company. This can be found at 2022 New York Slip Opinion 06029, published by the Court of Appeals on October 27, 2022. This is a civil case, and the issue in this case is the tension between statute of limitations and amendment of pleadings. And the question here is, does a breach of contract claim give sufficient notice to the defendant that a reformation claim should be allowed, even though it's barred by the statute of limitations? I'm going to explain all this in a few moments. The law you have to understand, what you have to understand this case, is that the statutes of New York don't want cases to be kept out of the courtroom by bright line rules, generally. One bright line rule is a statute of limitations. The statute of limitations says that a claim must be brought within a certain amount of time after it accrues. So you have a year from an intentional tort happening to file a claim. You have 2.5 years from a medical malpractice claim, things like that. But that bright line rule is tempered, it's mitigated by exceptions. One of the exceptions is found in CPLR 203-F, which says that an otherwise untimely case, so a case filed outside of the statute of limitations, beyond what would be allowed, will be okay, if the original claim was filed timely and gives sufficient notice of the transactions, occurrences, or events that are based in this new action. The other thing you have to understand is two other things. There's that amendment of pleadings is allowed by CPLR 3025. Amendment of pleadings is allowed. And the third thing you have to understand is that the difference between a breach of contract claim and a reformation claim. A breach of contract claim says that there was an agreement between the two parties. The plaintiff complied with the terms of the agreement. The defendant did not comply with the terms of the agreement. There was damages as a result, and the damages are due and owing to the plaintiff as a result of the breach. So that's a breach of a contract, breach of contract. A reformation claim, think about it as a reformation claim. It's the claim essentially is that although there's an agreement between the parties, this document, the paper that formed as a result of the agreement, is not the actual agreement. The agreement has to be reformed. This has to be modified to conform to the actual agreement reached between the parties. So we have to reform the contract after the fact. So what are the facts in this case? In this case, 34-0673 LLC is a building owner, and the building owner is the plaintiff. And the building owner makes an agreement or seeks to make an agreement with Seneca Insurance Company to provide insurance for the building, including fire insurance. Seneca Insurance Company sends over an inspector to look at the building and the inspector notes that the sprinklers don't work. Sends a letter to the plaintiff saying, by the way, you have to have functioning sprinklers as per the terms of our agreement. The plaintiff never fixes those sprinklers. And lo and behold, 4 months later, there's a fire in the building. There's extensive damage. The plaintiff files a claim with the insurance company, and the insurance company disclaims, says, we're not going to pay you because you didn't comply with the deal. The deal was you had to have functioning sprinklers, and you knew that because we told you that. The plaintiff sues and says, you are breaching our insurance agreement. You promised to provide us with insurance, and you're not. It goes all the way to trial, and at trial for the first time, the plaintiff seeks to amend the pleadings to add the untimely claim of reformation, saying, we had a deal. It's not in the paper, I understand that, but it's a mutual mistake that it's not in the paper. Your deal was to provide us with insurance despite not having functioning sprinklers. The judge allows it under 203F, even though it's untimely, because the judge thinks that the original breach of contract claim provided sufficient notice to the defendant. The jury returns a verdict about the reformation claim, granting it, and it goes to the appellate division. They affirm it, goes to the Court of Appeals. They say that was wrong. They say that a breach of contract claim, like this case, does not sufficiently apprise the defendant of the facts and occurrences such that it would be proper to allow the amendment to add the reformation claim. That it's unfair because the defendant might have acted differently, might have prepared for the trial differently, might have deposed different witnesses, might have sought different kinds of proof. And that it's not a fair application of that exception to the statute of limitations. So that's the holding. Breach of contract does not provide sufficient information for the reformation claim in this case. Too long didn't read 34-0673 LLC. Have a good day. If you like what you just saw and want to see more just like it, please hit like or subscribe to let me know.